All right, we are back with Doug Rohan, Rohan Law, to talk about some new developments in a little bit of a different angle. Not necessarily the FSU ACC case, though obviously pertains to everything going on with Florida State and the Atlantic Coast Conference. But Doug, how you doing, man? Thank you for joining us.
Doing great. Thanks for having me here. Pleasure to jump on board and talk about what Twitter is exploding over this afternoon.
Yeah, talk a little bit of drama before we both hit the road and try and go see the Noles win this regional in Tallahassee this weekend. So lay it on us. Attorney General Ashley Moody had requested the ESPN agreement a few months ago. We'll catch us up. What has happened since then?
So what we talked about before was that AG Moody publicly and very noisily expressed an interest in getting a copy of the ESPN agreement, sent a formal request for the disclosure of those many agreements to the ACC and ESPN, and they basically ignored her. So finally, last month, she filed what was called a writ of mandamus with the Leon County Court, basically asking for an order to be issued by the judge, forcing ESPN and the ACC to disclose their media rights agreement between each other, those two entities. And so today what we got was a response. Now, we got a response from the ACC. That is who the Attorney General Moody is filing this complaint against. But we also had the participation of ESPN, much like what we saw in North Carolina. But the third and biggest surprise of this was an amicus curiae brief from the other Power Four conferences. So the Big 12, the Big 10, the SEC have all jumped in, and along with the ACC are arguing that these media agreements should not be made public.
So the ACC, in your best estimation, before we get into the response, is okay with, as we just saw, Clemson got the documents, but they just don't want it out there. Probably by presumption, you could say that they're probably be more okay with Florida State having it than, again, it just going to the general public. Do you have a theory on why that is, why they are okay with the colleges having it, but they're not okay with TJ and Doug having a copy of it?
Well, the big sticking point here is the sunshine laws in the state of Florida. So the reason why the agreement has already been made public, already been shared with the parties in South Carolina, is because the attorneys in South Carolina could agree to say, we will review it, we will keep it private, we're not going to share it publicly. Well, because of the sunshine laws in Florida, the attorneys representing Florida State cannot make the same agreement, cannot make the same statement. Now, if Attorney General Moody had been patient and if we had waited, there is a process through which Judge Cooper can eventually, at the right time, issue a protective order saying, under order of the court, this agreement will be provided to the Florida State attorneys, and the Florida State attorneys are prohibited from sharing that. But that requires a judicial order. Attorney General Moody, probably looking for some political capital and to move this case along, as some of her constituents has wanted, made this a very public fight and brought this out in a way that probably is not going to be successful, but she wants to get access to those documents, and that would force or require a public disclosure, which all the conferences and all of the ACC and ESPN members are against. And keep in mind, there is, to your point of why TJ and Doug should have this agreement, one of the factors is a balancing test. What is the value in disclosing it versus what is the harm to be done to the parties in that disclosure? I don't need to see the agreement. As long as the courts see the agreement, as long as we get a ruling on what the agreements mean, it doesn't really matter what I say. It hurts my Twitter numbers and I can't get some good engagement from it. But other than that, I'm not the one engaging in business with ESPN or any other media partner. So there's very little, if any, value to the documents actually being made public other than everybody knowing what's going on.
Yeah, it seems like a bit of a petty move, but if anybody's watched this channel for long enough, they know that I don't have a huge problem with that. and certainly if it's, anti-ACC. So we got a response. Let's jump into that. You want to give us the short and then the long of what the response said?
Sure. Well, there's three factors that the ACC is essentially saying, and ESPN is echoing this. All the briefs are basically saying the same thing. First, that this is something that fits within the exception for public records. Two, the ACC and ESPN are not involved in state business. They're two private parties in a private engagement. And three, to the extent that the ACC was working as an agent for Florida State, it wasn't an exclusive agency agreement, and there isn't enough meat there to rise to the level that the Supreme Court of Florida lays out. The fact that there was a contract and agreement between the ACC and Florida State isn't sufficient to say that the ACC was acting as an agent for Florida State in negotiating these terms with ESPN.
Do you think that the ACC, like kind of like how Florida State's not Florida State, how the state of Florida is maybe being petty in the way that, you know, or AG Moody is trying to get this. Do you think the ACC has and ESPN have legitimate reasons for wanting this document so locked up and kept tight, or are they just trying to fight? They're going to fight every single thing that the other side does in this case as well, or do they have some legs to stand on why they want to keep it pretty hidden?
No, I think there's legitimacy to the ACC and ESPN position. It's not just about the facts and figures that are outlined in the agreement. Of course, we want to see it from a strategic standpoint to argue the Florida State position in the Florida State ACC litigation. But as far as the disclosure, there's several reasons why the position of the ACC and ESPN are correct. First off, we do get to see the numbers, the expenditures on TV for each conference, but that's just one single figure that's not broken up into its necessary parts. It's just showing, for instance, last year that the ACC paid out $443 million to all the TV partners. Doesn't say how it paid that out, what that covered, what that entailed. So there's a lot of details that remain in that agreement that aren't covered by that single disclosure. The second thing is that's always looking in arrears and behind in the past. So there are groups out there that are trying to reverse engineer what those numbers mean and make guesses as to what that meant for each conference member, but there is no certainty as to what that is. The third thing is that it doesn't talk about what the future agreements are. It doesn't talk about what the future compensation is going to be. So maybe there is something like, I don't know, for instance, an option to extend the agreement beyond 2027. Those are the types of details that ESPN doesn't want to see disclosed. And in this case, the ACC is basically arguing all those same points. The ACC would likewise be at a disadvantage in their negotiations with their media partners if the other conference members knew what the terms were in that agreement between Florida, the ACC and ESPN.
Is, if maybe I'll ask you to speculate on this, if they hadn't kept it so locked down, and maybe they kept it so locked down because of the sunshine laws, because once it would have gotten to Florida State, maybe then it would have had to have gone out. So maybe I'll give them a little grace before I even ask the question. But it's almost like if they hadn't kept it so locked down and it was just a little more accessible for Florida State over these last couple of years, would we maybe not even be in this situation? Would we maybe not even care as much about the agreement if it wasn't so hard for Florida State to have access to it over the last couple of years?
I don't think so, because it either is published or it's not published. And the bottom line is that ESPN has successfully prohibited the publication of their agreements. That's another one of their arguments. Never in the history of all the records requests that have been made has any court ordered the publication of these media agreements. So on the one hand, they have successfully defended the secrecy of these agreements. Second, to point to specifically the ESPN agreement and the ACC issue, they talk about in the complaints about how there are only 4 ACC employees that have initial access to these documents. So in order to get to them, you have to go through one of 4 employees. That provides accountability. If there is a problem, we've got a 25% chance of knowing who created the problem in disclosing it. And then third, that disclosure or lack of disclosure is an element in this trade secret dispute. So in order to claim that these are trade secrets, one of the things you have to establish is the efforts made to maintain the secrecy of those agreements, to which the ACC and ESPN have successfully done enough to protect those agreements from disclosure.
So you made this comment when we started. Just thoughts overall on what ends up happening here. I mean, you even kind of made the comment that this may not be successful. Is there a chance that a judge would side with Attorney General Moody, or is this kind of just more fun than anything, or more noise in the echo chamber?
I think this has more to do with political grandstanding in an election year than in actually securing the release of the documents. I don't think that Attorney General Moody is going to be successful. I don't think that the judge is going to order the disclosure of these documents publicly. I think it may speed along the process of Judge Cooper having this addressed, maybe even in the June 18th hearing that he set aside. Maybe that's something that they're going to address so early on as they did in North Carolina. So I think that this provides some urgency to the parties in the FSU ACC litigation, provides some urgency to the parties FSU, ACC, ESPN, and settlement negotiations. But as far as the Attorney General versus the ACC, I don't expect much to come of this.
Would you expect, like you said, hurrying other things along and getting Judge Cooper to maybe even deal with some of this? Would you expect that Florida state's attorneys could potentially get access to this document like Clemson's did, and Judge Cooper kind of shield it like you were maybe referring to earlier? Like, do you expect that to happen at some point in our case in Tallahassee?
Yeah, that's why I said the AG was kind of being pushy and not being patient. There will come a time where Judge Cooper will issue an order of protection saying that the unredacted agreement has to be made available to the Florida state attorneys, and the Florida state attorneys are prohibited from disclosing that or filing anything publicly. That's the protection that the Sunshine Laws are requiring to be put in place. The thing is, the Florida state attorneys couldn't unilaterally agree to that. They couldn't agree to not disclose it because their legal obligation is to disclose everything that they have access to.
When that happens, I guess Florida State's already seen them when they've traveled to Charlotte, when they've done things. So, that I guess it'd be fine there. So I won't even go down that path. The other interesting part is the other four conferences getting involved here a little bit.
Other three conferences.
Other three.
ACC's already. Yeah.
We're down
to the Power Four.
But yeah. What were the thoughts there? Or did they kind of just echo what everybody else said, or was there anything kind of interesting out of those?
The fact that they even filed anything is what's interesting. Their presence is the interesting eyebrow-raising aspect of this. The brief itself, they filed first a consent motion, which means all the parties agreed to it, but just formally asking the judge to be allowed to submit a brief. And then Exhibit 1 was the brief of the party. So one attorney writes, meeting with all three conferences and the attorneys of all three conferences, and they put together one consolidated document to submit to the court, basically rubber stamping the opinions of ESPN and the ACC. So there wasn't anything earth-shattering in the amicus curiae brief that was submitted. It was just curious that there was an amicus curiae brief. That was the interesting development.
Anything else high level about Attorney General Moody or this situation specifically? And if not, we can talk a little bit about our timeline. You mentioned June 18th, but we can kind of go into what is going to happen there and that day.
Yeah, the only other thing I was going to mention was if you compare the three briefs that were all filed and submitted, there is a difference in the voice and in the tone. And the ACC is being very spicy and is being very antagonistic to the Attorney General. ESPN and the amicus brief both say exactly the same thing. They just don't say it with the voice and the language that the ACC is very clearly coming at. So you sometimes see the personality of the attorneys in these pleadings, but their ACC attorneys were effectively calling Attorney General Moody a liar to her face in several instances. So that's just one example of how all three are saying the same thing, but they're not saying the same thing. They're saying it in a different way.
When you mentioned I don't know if I'm going tinfoil hat or not here or not, but you mentioned you see some of the personality of the attorneys. does the ACC or does Florida State at times will they advise on the attorneys like, hey, yeah, like go for the absolute throat here. Like we want you to make this like a public spectacle or like have those parties like kind of resign themselves to just like, hey, the ball's in your court. You do what you want. Or does some of that, when Florida State was spicy a couple of weeks ago, does some of that come from the actual client, I guess, saying, let's ratchet this up a little bit to make it a bigger thing or whatever?
I think I'm speculating here. I wasn't in the room. I'm not talking to these attorneys. In my experience, it comes internally within the firm. We just had the discussion today on a case. We're writing a response brief where the defense firm was saying something utterly ridiculous, and I basically gave my associate the green light to get nasty. And so that's a decision that happens internally because sometimes you just have to show the judge, you see what I'm dealing with? This is what I'm dealing with. This is why I have to be here having this ridiculous conversation because of stuff exactly like you're reading in this other brief. That is an internal decision within the attorneys as a strategic choice here. I don't think that Florida State is telling their attorneys to get ugly. I don't think that Florida State is telling Attorney General Moody anything to do with this process. In fact, it is possible. I'm still speculating, but I can see a scenario where Attorney General Moody went forward on this without really consulting the Florida State team on this strategy. But the bottom line is, to your question, the person writing and typing at the keyboard has a lot of authority in what the brief sounds like, and their views and their personality is going to come through in their writing.
Yeah, that makes sense. We've got a hearing coming up on June 18th in which the judge in Florida wants to get a lot done on the 18th. And I know that the Florida case has been stretched out, but the 18th is a big day for both Florida State and the ACC.
I think Judge Cooper wants to get everything done on the 18th. That's basically what he's saying in his writing. There's a lot to address here. There's a lot that's still involved. The problem is we still haven't seen the ACC response to the second amended complaint. We don't know what additional motions they're including, if there's another motion to dismiss, another motion to stay proceedings, what other new and interesting motions they might come up with. We've got this issue of the agreement and whether or not it should be disclosed. Are they going to talk about that as part of this June 18th hearing? Now, he set aside from 9 to 5. I suspect if they get close to 4:30 and they're not done, maybe they would continue it to another day. But Judge Cooper is really laying down the language like he wants to get it done as soon as possible.
So we will get some clarity then. Like, will he make a ruling then, or will we have to wait a couple of weeks to get something in? I mean, obviously we'll have to wait a couple of weeks to get something in writing with how long that case is or that hearing is going to be. But will he make a ruling that day?
Twice he's ruled from the bench. The first time it took 4 weeks to get the order reduced to writing. The second time it took 2 weeks to get the order reduced to writing. This is probably a combination of both of those together cumulatively. So I wouldn't be surprised if either he chooses not to issue a ruling from the bench or he issues his ruling from the bench and it takes 6 weeks to get the written order on all of the different issues and topics that we're going to be covering.
So at that point, we'd be looking around August 1st as maybe a best case, maybe not best case, but a realistic timeline.
Just in time for one of the parties to appeal the decisions and send it up to the Florida Court of Appeals, which will add another 90, 120 days to the process before we even get started.
It is, when we started this back on December 23rd, I don't think, and people said it then, like this could be a 12 to 18 to more, months process if it continues out, right? If they don't settle or whatever. But I don't think that I was like, scoff at that. Like they'll get it in court and we'll just get going. But the delays and the redos and the appeals and this is a lengthy process. So hats off to you guys that work so hard on getting it done.
This is how the law works.
Speaking of August, a little bit different. We'll go a little bit different direction and then we'll get out of here. But I've seen this. You've got a little bit of a way that people that are going to Dublin can interact, stay updated, stay informed on things that may happen over there. You want to tell the folks about that?
Yeah. We've got a link. We'll include it in the link below, and we'll share it with the tweet when this video comes out as well. But yeah, we are putting together our resources to perhaps make sure that we have a coordinated message and conversation with those Seminoles who are in Ireland and may wish to share some of their feelings about what happened at the end of the last college football season. So we're asking people to register, and we're going to have some information that comes out. We've got a couple items for you to consider buying from Amazon. We've got a couple apps that you might want to download to stay in communication. We'll, of course, share any information about maybe a meetup up there, and then just have some opportunities for us to, like I said, be a more coordinated voice when it comes to sharing our thoughts and opinions under certain circumstances and in certain situations while we're in Ireland.
I haven't talked to Doug about this, so he may smack me back down. But I have chatted with some people at the Tallahassee Beer Society, and as much as I want to go over there and drink Irish beer, that have asked me about taking some Tallahassee beer to Ireland and then just getting some photos of us drinking, which, I always have room for one more, right? So getting some photos of drink. And so, yeah, whenever we do, we're going to have to do a meetup. I don't know that it'll be a Double Fries Rohan Law, live event, maybe live streamed or something off somebody's phone, off Harlan's phone. But we'll definitely have to get together and share some beers over there. Irish, German, American. I'm here for all of the beverages. So
here for all of it.
Doug, where can people follow you? Where can they find your social media, and tell us just a little bit about Rohan Law?
Check us out on X or Twitter first at Rohan Law PC. I'm sure most of you that are watching are involved in keeping up with the ACC FSU litigation. So that's where I share my thoughts. Of course, whatever social media platform you use, Rohan Law PC has a presence, and we share information about our law firm located here in Atlanta. And we talk about different ways that we want to be your best friends on your worst day. We handle criminal defense and work accidents. We want to make sure that if you're going through a difficult time, that you have a partner to come alongside you, a fellow Nole, and help you with those difficult circumstances. And of course, if you need help finding an attorney, I've actually, in this past week, maybe we finally reached critical mass, but I've had 3 or 4 Twitter people reach out for me, not for something here in Georgia, but for something in Florida. And I'm absolutely happy to help out. I went to law school at Florida State. I still have lots of friends in Tampa and South Florida and in Jacksonville. So I'll make sure that you get put together with a quality attorney that can help you with your legal needs. But you should always start with Rohan Law for any problems or questions that you have.
It's awesome. It's awesome. If you're going to be in Tallahassee tomorrow, Doug and I are one day only, so hopefully this regional only lasts 3 days and wrapped up on Sunday. But if you're going to be in Tallahassee tomorrow, let us know in the comments. Let us know on social media. I'll let you buy Doug a beer at the Animals tailgate, and
I'll be there about 10:30 in the morning under the oaks.
Yeah, so come hang out if you're going to be in Tally. It's going to be a hot one, but you just got to stay hydrated and you'll be fine.
Exactly.
Doug, I appreciate you for joining us, man. We'll talk to everybody soon. Thank you guys, and go Noles.
Go Noles.